4, 3, 2, 1.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning. Before Madam Clerk calls the case, just a couple of things that if we don't anticipate any technology problems, but if we should have any, we'll take a pause and we'll work through it. Nobody panic. We're usually able to, I don't solve any of the technology problems, but they're usually solved. All right, call the case, please, Madam Clerk.
Gene Lovelace Enterprises, LLC et al. Versus City of Knoxville et al.
We'll hear from the appellant.
Thank you, Your Honor. My name is Matthew Grossman of the Knoxville Bar, along with Rebecca Harbin. We represent the plaintiffs, the appellants in this matter. And there's frankly a whole lot to unpack here. This case has been around for a little bit. It was originally filed in 2005. So I'll just do a very, very brief background and move on to some points that maybe need a little more addressing after the briefing. This is the second appeal of this case. I'd say approximately 5 years ago, a panel of this court, Judge Frierson authoring the opinion, reversed a prior grant of summary judgment in favor of the city from the trial court, essentially holding that the trial court impermissibly ignored the business's evidence in opposition to the motion for summary judgment. And this is a, for lack of a better word, it's a case involving adult entertainment establishments, and but in essence, it's just not much more different than any ordinary summary judgment case. Anyhow, again, this is the second appeal of this matter. This case involves the City of Knoxville Municipal Code, Section 16.471, which imposes certain regulations and frankly, building and land use impositions upon businesses that fall within its purview. This ordinance was originally presented to the Knoxville Metropolitan Planning Commission in 2005. It was rejected by the Planning Commission, and then it was brought to the agenda of the Knoxville City Council. As I'll discuss a little more in a minute, that was done without appeal as set forth in the other parts of the Knoxville Code governing appeals to following adverse rulings of the Planning Commission.
Was there a reason set forth by the Planning Commission why they rejected acting on the ordinance?
It doesn't go into great detail of the basis. Basically, there was a roll call vote, and it was rejected. The city would have the court believe that it was rejected because it wasn't properly before the Planning Commission. But the record of the Planning Commission, in my view, makes clear that they were considering the merit or lack thereof of this ordinance. There was, for example, a lot of discussion, particularly there's a Commissioner Graff who discussed at length that he was developing a subdivision that surrounded my client's business on Alcoa Highway in South Knoxville, and that these business that in his view that the existence of this business did not impact or hinder his ability to develop the property. He even showed it to people who were buying houses in that subdivision, and basically said, doesn't cause any trouble here. And I believe that the Planning Commission, hearing that statement of one of its own members, indeed addressed the merits and therefore rejected it. Now, again, I'm not sure if that distinction is germane or not, but I think it is certainly worth noting because that is evidence in this record that we have relied upon in opposing the summary judgment. Nonetheless, after this ordinance was placed on the City Council agenda, the City Council approved the ordinance as it was written and as it was presented to the Planning Commission, and it enacted it. Although the record reflects that it has not been enforced since enactment over some 15 years. Unless the court has questions about it, I believe the summary judgment issue and how it interplays with the burden shifting analysis in the Alameda Books case, I think is fairly substantially briefed by the parties. And I'll just say principally, The same defect with the trial court's previous grant of summary judgment exists in this case. The businesses in this case have presented testimony in the form of the affidavits of Drs. Miller and Fisher, which address each and every of the matters raised in the legislative predicate upon which the city necessarily relies to support this ordinance, which admittedly abridges free communication. And for that reason, we believe, and in our reply brief, we actually drop a footnote about 3 or 4 pages in that shows the pinpoint site to every matter being put in dispute. And therefore, there's a genuine issue of material fact for trial. And as a matter of summary judgment jurisprudence and the burden shifting analysis, the summary judgment simply cannot stand. And the court should reverse on that basis. One thing that's a little bit interesting about this case is that, as discussed, is these 2 ordinances were initially presented to the Knox County Knoxville Metropolitan Planning Commission. Again, the city contends that the ordinance that is the subject of this litigation did not have to go to the Planning Commission, but nonetheless, the city's attorney at the initial hearing before the Planning Commission acknowledged that the regulatory ordinance had a locational component to it, which is entirely true, because as set forth in the record, matters included in this ordinance that the city would have the court determine are entirely licensing involve matters involving erection of a fence, wall, or barrier that on the premises requires certain signage to be on these premises. It has specific guidance as to internal configuration of the buildings in which these businesses operate. And it also essentially incorporates the balance of the Knoxville zoning ordinance and denies issuance of a permit unless the business complies with the internal configuration requirements. And so for this reason, we believe that the ordinance is simply, we have not moved for summary judgment, but I think we would be entitled to summary judgment on this basis. This ordinance is simply procedurally infirm. Including a couple of judges on this panel recently in the case of KCDC versus Orchard Entertainment, made it very clear that the city of Knoxville, when it provides for appellate remedies, the city and its agencies must follow those remedies. And that's exactly what we have here. Is it's undisputed that there was no appeal from the Planning Commission to the City Council filed, and B, none of the requirements of the appeal were subsequently followed, such as basically everything that's set forth in the ordinance, such as publication principally. That's just it's a requirement for any appeal. Now, for that reason, we believe the city simply cannot get summary judgment because the ordinance fails. It's essentially a nullity for failure to comply with the procedure.
Council, what would have been the effect if it had been an appeal to council?
Well, I think then
what would have been different?
I don't know. I don't know what would have been different. All I know is that if the city has a procedure for an appeal, it has to follow it.
How would you know it was an appeal, or just they brought it up? Just the fact that nobody said, the city didn't file an appeal?
Yes, Your Honor, because the record before the city council would have included that appeal form, and it's not there.
All right, and what would have been different if it had been appealed? As far as procedurally, what happened? What would have been different?
They would have published notice in the newspaper, so the public would have had notice that there was an adverse finding against the city and the Planning Commission. The public would have been more advised as to what was going on here. And basically, I'm not saying the outcome would have changed.
I know I wasn't asking about the outcome. I was asking just procedurally what would have been different. If
well, procedurally,
what happened?
Procedurally, the city law department would have filed a document, I guess, with the city recorder. I think essentially functions as the clerk for these purposes, and then the city recorder would have placed the matter on the city council agenda. That's not what happened here. What happened here was the law director simply placed the matter on the council agenda without following those procedures.
But it was placed on the council agenda, which is what would have happened if the appeal had been taken.
Well, and it also would have followed the other requirements. There would have been a document stating the appeal and what was specifically being appealed. It would have provided, again, for the public notice, and then the matter would have proceeded within 15 days pursuant to the appeal ordinance.
Okay.
But again, the procedure simply wasn't followed. Very briefly, just the case is principally relied upon by the city as to the land use component of this. Cherokee Country Club and the fireworks case out of Jefferson County. Cherokee Country Club was ruled against the city on the basis that really that things have to go through planning commission if they affect the use of land. And I see I'm out of time, but in the Jefferson County case, Jefferson City case involved fireworks and it had nothing to do with the location. It's just that you can't sell them.
All right, you have your time for rebuttal.
Thank you.
We're here from the appellee.
Your honors, may it please the court. Scott Burkville on behalf of the appellee, the city of Knoxville. We ask that this court affirm the summary judgment that was entered below. This is not a case in which the prior appeal said that the trial court particularly ignored anything. It's just that the trial court's original summary judgment order was a one-page order that did not engage in the analysis that this court's decision in 2014 said needed to be followed. So on remand, the trial court received additional briefing, conducted a thorough analysis, and issued a 15-page summary judgment order explicitly following the instruction of this court's prior decision. I'm going to take the issues that Mr. Grossman raised in the order that they would follow chronologically, which means address the procedural licensing zoning issue first, and then proceed to the Alameda Books analysis that the trial court engaged in. What happened when this went to the Metropolitan Planning Commission in 2005 is that the city was on the heels of the 2004 decision from the Supreme Court in Cherokee Country Club. There are two ordinances that were being taken up, principally because the Supreme Court, or this court, had invalidated or struck down the Knoxville zoning ordinance as it pertains to adult business in an unrelated matter dealing with adult businesses. So when they revamped their ordinances in the wake of that adverse judicial ruling to bring their ordinances up to date, to cure the constitutional defects that this court had found in the prior version in an adult bookstore case many years ago, there were two ordinances. There was an amendment to the Knoxville zoning ordinance, and then there was, we call that the location ordinance, and then there was the licensing ordinance that just deals with business licensing and employee licensing for adult businesses. Out of an abundance of caution, they took both to the Planning Commission, but contrary to my opponent's argument, the Planning Commission didn't say we're not going to approve this because of the merits. The Planning Commission recognized that this is not an ordinance within its purview. At page in the technical record, volume 2, at page 145, there's a portion of the transcript from this Metropolitan Planning Commission meeting where Commissioner Evans says ordinances like this that just licensed businesses don't need to come through here. And then he said it doesn't have anything to do with the restriction of property. So ultimately, the vote to not make a recommendation was a recognition that this was a licensing ordinance, that yes, the location ordinance had to come through Planning Commission. Mr. Grossman's argument, frankly, is mischaracterizing the record as to what Morris Kaiser, the prior law director in Knoxville, did and what he said. And we addressed this in detail at footnote 6. It's about a 20-line footnote at page 49 of our brief, where we go through in detail, and it makes it very clear that what Mr. Kaiser was talking about was the locational ordinance needing to come through the Planning Commission, whereas the licensing ordinance did not, because it only licensed businesses. There's no reference in the licensing ordinance to zoning districts, location restrictions, where an adult use may operate. And under the SNPCO test that we laid out in our brief, in order to be treated as a licensing ordinance, an ordinance must do two things. Number one, it must be so closely related to the city's comprehensive zoning plan such that it's tantamount to zoning. And number two, the challenged ordinance must substantially affect the use of land. So it was irrelevant under that fireworks case that it involved a ban on fireworks, while this is a regulation and not a ban on sexually oriented businesses, because neither ordinance was tantamount to zoning. Rather, the licensing ordinance is a 20-page police power ordinance that licenses employees, sets regulations for the businesses, regulates hours of operation, bans nudity, deals with patrons having to be 6 feet away from semi-nude dancers, things like that. It doesn't specifically mention zoning. It just simply says that one of the conditions that you get a license is that you comply with zoning in other parts of the code. So it's very clear that though not required, the Planning Commission just decided not to make a recommendation one way or the other to the City Council. The second argument about this appeal just proves that this is not the type of ordinance that needed to go through planning or zoning procedures. Mr. Grossman cites to the zoning ordinance, Article 7, Section 6F sub 1. And when it talks about making an appeal, none of the things in that section have any relevance to the licensing ordinance. In other words, it says that a party who is aggrieved by the City Council or the Planning Commission's decision should implement this appeal and specify in that appeal what zoning change they are seeking, which that doesn't apply here. Number two, the specific parcel of property that they're seeking the change for. And of course, this doesn't deal with a specific parcel of property, and why they would be aggrieved. So all of these particulars of the zoning appeal procedure just prove that this isn't the type of ordinance to which this applies. The KCDC case that Mr. Grossman references is also in a posit because it involved eminent domain, not adopting legislation. The state statutes on eminent domain say that you have to have a very narrow construction of the eminent domain power in order to avoid licensing it. And the problem in that case was the ordinance basically deprived a party, an aggrieved party, of the ability to come before the Planning Commission and the City Council and to weigh in on whether an eminent domain proceeding should be initiated before that proceeding was initiated. Has nothing to do with what we're doing here. This is a licensing ordinance that does not restrict anything relative to land use. In other words, if this is in a C2 zone and there's 28 land uses that are allowed in the C2 zone, all those 28 land uses are still allowed today. If it's a sexually oriented business, yes, they have to comply with a stage requirement, which has been upheld in dozens of ordinances. Dancers have to be on an 18-inch stage, but that's not that's something specific to a sexually oriented business. That's not a regulation of what uses to which the land or the parcel can be put under the zoning code. So the trial court properly ruled on that and granted summary judgment on that issue. And I think as Judge Swiney recognized, the outcome was it went to the City Council. It was on the agenda at a properly noticed meeting. They had two separate hearings, and the City Council passed this licensing ordinance. They were not required to apply an appeal procedure that doesn't have any relevance here. Number two, the second argument that my opposing counsel makes is about Alameda Books. And this is probably the clearest case on a summary judgment. There are dozens and dozens of cases from the Sixth Circuit, from the Tennessee Court of Appeals, from federal appellate courts around the country where adult businesses have hired experts to try to come in, including Dr. Fisher and Dr. Miller, these two experts, and those cases repeatedly affirm summary judgment over the objections and contentions of the plaintiff's experts. And the essential reason is they don't create a genuine issue of material fact under the governing law. The governing law is that a city council, a legislative body like the Knoxville City Council, may rely upon, quote, any evidence that is reasonably believed to be relevant to its secondary effects concern. That goes all the way back to 1986 with the U.S. Supreme Court decision of City of Renton versus Playtime Theaters. In that case, for example, the only thing that the City Council in Renton, Washington relied upon was a single state Supreme Court decision upholding a similar ordinance from Seattle, a town a half hour away that was 20 times the size of the city of Renton. And the U.S. Supreme Court reversed the Ninth Circuit Court of Appeals decision, saying that the city should have relied on evidence specific to Renton, so on and so forth, and more methodologically sound studies and all that stuff. The Supreme Court said that a city can rely on, does not have to produce evidence in the local jurisdiction, but rather can rely upon, quote, any evidence reasonably believed to be relevant. And from the case law, we know exactly what the governing law, what fits in that body that a legislative body can rely upon. They can rely upon judicial studies. They can rely upon anecdotal testimony from citizens at city council meetings. They can rely upon investigator affidavits. They can rely upon land use studies. They can rely upon cases that have been decided in judicial authority. They can also rely upon expert studies. And in this case, the City Council of Knoxville relied upon all of those things. Mr. Grossman's clients put in some reports from their guys and trying to challenge it. The city hired its own PhD, a recognized criminologist, Dr. Richard McCleary. Mr. Grossman's partner, Mr. Seymour, got up and argued about the data. The city council heard this entire debate and they adopted the ordinance and they made specific findings. And the burden on a challenger is to show that the city had no evidence that was even reasonably believed to be relevant under Renton and Alameda Books' deferential standard. In order to carry that heavy burden, they have to attack every single piece of the legislative record. And they didn't do that. Dr. Miller said, I'm a handwriting expert. I've never studied the issue of secondary effects before this case. I spent maybe a total of an hour looking at the 1,600 pages of studies, reports, judicial opinions, and expert reports and analysis supporting the city's ordinance. But I just simply disagree with the courts that the city of Knoxville can rely on information from elsewhere and other jurisdictions. That's where I disagree with the court. So that clearly is not an opinion that precludes summary judgment. Similarly, Dr. Fisher, whose opinion has been rejected as insufficient to preclude summary judgment on behalf of a local government in many cases. Those cases include Peekaboo Lounge versus Manatee County, Florida, which is at 630 F3rd 1346 from the 11th Circuit in 2011. A similar case called 5634 East Hillsborough versus Tampa or versus Hillsborough County, Florida. Daytona Grand versus City of Daytona Beach, which is cited in our brief. That's 490 F3rd 860. In all of these cases, what the courts say is that Dr. Fisher, first of all, failed to address a lot of what the city relied upon. And that was, he didn't address any of the judicial opinions. He doesn't say why the judicial opinions are not something that the Knoxville City Council can rely upon to support their findings concerning secondary effects. He doesn't deal with the Lundy affidavit, which was documenting paid sexual contact at the adult club that is the appellant here. And I get into all the gory detail in the brief, but the point of the matter is there's just nothing that Dr. Fisher said, or frankly could have said, that would disprove the idea that having erotic dancing take place on a stage that's 18 inches off the floor and 6 feet separated from patron is not going to serve the substantial government interest of preventing the paid sexual contact and the bump and grind, simulated coitus and other illicit sexual activities in VIP rooms and prostitution in back rooms of strip clubs. There's really no scientific data that you can disprove that. So Dr. Fisher doesn't address that at all. And the Sixth Circuit's decision on this is really good, not only for upholding the Knox County ordinance that's basically identical to this ordinance, but also the Sixth Circuit's decision out of Shelby County, Tennessee, in the entertainment productions case that we cite in the brief. The Sixth Circuit said that, quote, the First Amendment does not demand empirical support, let alone a specific methodology to sustain a regulation on erotic expression, end quote. And in that case, there was a much more detailed, comprehensive expert report, but essentially what the Sixth Circuit like the Tennessee Court of Appeals and American Show Bar and so many other cases say, is that these experts don't come in and disprove that the city failed to rely on anything in that 3,000-page legislative record that was even reasonably believed to be relevant to the negative secondary effects question. Instead, what these experts come in and say is basically a legislative body should be held to Daubert type standards, that we should apply these comprehensive multivariate regression analyses to legislative evidence. And we should hold the city council in Knoxville to this expert witness standard in order to pass legislation. And the Supreme Court, the Sixth Circuit, and frankly, this court in prior opinions has repeatedly rejected that assertion. And so what this establishes is that there is a number of things in the legislative record. In fact, look at how it was presented. Mr. Grossman said, well, we dropped a reply brief in our footnote, we have this super long reply brief. First, that footnote with a bunch of record citations was not presented to the trial court, who did a thorough job of analyzing this challenge. Number two, it's not even explained in his reply brief on appeal. It's waived because it wasn't raised below. It's waived because it wasn't raised in the opening brief, but it's not even explained in the reply brief. But even when you go through that, all it is that Dr. Fisher wants to hold the city council. First of all, he doesn't address a number of things like judicial opinions in the Lundy affidavit, but he wants to hold the city council to a higher methodological standard. Under governing law from Renton and Alameda Books and all the courts that follow them, that is not sufficient to preclude summary judgment. That's why his opinion has resulted in the affirmance of summary judgment in many cases. I see that I'm out of time, but would be available for questions.
I hear none. We'll hear from the appellate rebuttal.
Thank you, Your Honor. I'll confine myself to my time. Very briefly on the zoning question, just that was Angela Bolton for the city, not Morris Kaiser. And essentially, and she did, the record's clear, she did state that this has a locational component to it. And the city essentially is asking this court to bless, frankly, in any kind of zoning case, a non-appeal of an adverse ruling from the Planning Commission, and that simply can't stand as precedent. Now, the things that make this case different from the Knox County case and any other cases, we have Dr. Miller's report and we have his affidavit. Dr. Miller and Dr. Miller's affidavit and report were not objected to. There was no request for a Daubert hearing or McDaniel or anything. That's before this court as it stands. Dr. Miller testifies that
Counsel, excuse me, but is the standard, your opponent says these cases, case after case after case, have said even at the summary judgment stage, what you're still looking at is whether or not there was any evidence that the government, because here at the council, could reasonably rely upon. Not whether or not there was really a question, but was there evidence presented that they could reasonably rely upon, even though you may have experts saying contrary?
Well, and I would respond to that this way. Dr. Miller gives unresponded to testimony that the city could not have reasonably relied upon this record. And the record further bears out that the city council did not rely upon this record. Councilman Bailey, who in fact voted for this ordinance, stated to a local newspaper, I did not buy what this attorney, Mr. Bergfold, was saying about our community. It didn't hold true to this area. If you're an attorney, that's a good way to make a living. I'd like to have a business like that. He spends 50% of his time creating a lawsuit and the other 50% of his time defending it. This is from a member of the Knoxville City Council who voted for this ordinance. He clearly did not reasonably rely upon this data. He says he didn't believe it. Another thing he said, I felt it didn't matter. I didn't believe any of which this guy, Mr. Bergfold, said. It seems to me like he's just a franchise and goes around from city to city and sells these lawsuits and municipalities pass them. And then we hire him to represent the city at $200 an hour. These are the words of a member of the Knoxville City Council. That coupled with the unobjected to testimony of Dr. Miller clearly makes a dispute as to the reasonableness of the reliance upon this predicate. Now, I think, frankly, I know I have about 2 minutes left, but I think that's really about where I want to finish. We have a genuine issue of disputed material fact. It is the reasonableness of the city council's reliance on this predicate, and the city cannot prevail on its burden at this stage because of this undisputed evidence in the record.
Timmy, our thanks to counsel for both sides. We appreciate your briefs and your oral argument. The issues are obviously set out very clearly, and we think we understand what our task ahead of us is. Madam Clerk, if you'll recess court till 10:30, please.